Hello friends. Today we are going to discuss about vicarious liability from medical negligence perspective. I am Dr. Suresh Badadmat, Professor of Psychiatry working at NIMANS, Bangalore. Vicarious liability from medical negligence perspective. Whether it is applicable in India or there any Supreme Court judgment will be discussed in this video. Vicarious liability is a Latin legal maxima. It is Q facet per alium facet per se. That means, he who does an act through another is deemed in law to have done it himself, or liability by relation. As a general rule, whenever a person commits an act which is unlawful, that person is held liable for this wrongful act and he is punished accordingly. That is the general rule. But however, in certain situation, a person can be made liable even if he has not done the act or he has not done the wrong. It is done by someone else with whom he shares certain relationship. That relationship can be master and servant. In such case, the master can be held liable for the servant's wrongdoing. That means, vicarious liability is a liability of a person for an act committed by another person, and such liability arises due to the nature of relationship between the two. This can be the relationship between two people, or else a person and an animal, or else a person and an institute. For example, the hospital may be held vicariously liable for the mistakes or the medical negligence or the negligence done by their staff, or the faulty techniques or the faulty equipments or the structures, the way they have built, or the facilities they are providing. Although the establishment may not be directly responsible, it is responsible through the agents such as employees of the hospital. And also it comes under master-servant relationship. Here the master employs the services of the servant and he works on the command of the master, and thus a special relationship exists between the master and the servant, that is between the two. In case if the servant does something wrong which is unlawful, the master will be held responsible. That is vicarious liability. There are two types of vicarious liability which has been explained in the literature. That is Q facet per alium facet per se, or the Respondeat Superior is the other second one. Let's discuss both of them. The first one is Q facet per alium facet per se. It means that whenever a person gets something done by another person, then the person is viewed to be doing such an act by himself. For example, Mr. A is a driver who works for Master B. While driving the Master's B car, A is rashly driving and hits a person called as C. Now, though the vehicle was driven by A, Mr. B will also held liable for the accident. In such a scenario, that is called as vicarious liability. The driver would have been the person who is committing the unlawful act, but he is under the direct control of the master. That is Mr. B here. So, although the driver should have been held responsible, the master will be held responsible and he will be paying the compensation on behalf of the driver. That is what it means, Q facet per alium facet per se. Let's understand the second concept, Respondeat Superior. That means, let the master answer, is a legal principle that holds an employer liable for the negligence of its employee in certain circumstances. It means that the superior should be held responsible for the act done by his subordinates. The best example I can give you is in a medical college or in a corporate hospital, the case where a senior specialist will delegate his work or his surgery or a procedure to the junior most doctor. He may be a postgraduate student or maybe an intern. If anything goes wrong in such a procedure, then the senior specialist will be held responsible for delegating the work for his junior. That is, Respondeat Superior. So these are the two important vicarious liability maxima which has been described. Let's understand the essential ingredients of this vicarious liability. The first and the foremost, the servant has committed an act which amounts to a tort. The tort is a civil case. That means it is not applicable in criminal case. Such a tortious act is committed by the servant during the course of an employment under the master is very essential. Let's understand why the master will be held responsible. The traditional view is the test of control. Here the master, the employer, is the one who chooses whom to employ, that is the servant. He prescribes the work, manner of performing the work, providing the salary, providing the reinforcement, punishing for not doing the work or doing wrongly, and he retains the power over the servant. And he has all the power to remove the person from the job. That means the master is delegating his work or doing his work through his servants. Hence, the master will be held responsible through the test of control. That means master controls the servant, hence master will be held responsible for the servant's unlawful act is vicarious liability. The application of this principle will not be administered in the criminal case, as this is involved in personal liability with regard to negligence. Let's discuss one of the important Supreme Court's decision with regard to vicarious liability. This is Maharaja Agrasen Hospital versus Rishabh Sharma. This occurred recently in 2020. The Supreme Court gave the verdict. Let's understand the facts of the case. A complaint was lodged by Mrs. Pooja Sharma, that is the mother of Master Rishabh Sharma. He was an infant. On the ground of medical negligence, the case was filed against Maharaja Agrasen Hospital for retinopathy of prematurity. Let's understand how it happened. On April 2nd, 2005, Mrs. Sharma had undergone an emergency cesarean section on an account of placenta previa, and it was a premature delivery. On the same day, Mrs. Sharma was referred to intensive care unit of another hospital, that is Maharaja Agrasen Hospital, because where the delivery occurred or the cesarean occurred, there ICU for children or the pediatrics was not available. Hence it was referred to Maharaja Agrasen Hospital. The infant's condition was very poor. Hence infant was admitted in ICU and it was looked after by the pediatrician under the ventilatory support. The infant stayed in the ICU for 27 days after the birth, and the child improved and the child was discharged to the mother. At the time of the discharge and also in the subsequent follow-up over a period of 1.5 years, there was no mention of retinopathy of prematurity. Examination was not done, or it is not mentioned anywhere in the medical record, and even it was not prescribed to be done by an ophthalmologist. Hence, after 2 years, mother Mrs. Pooja Sharma realized the child was unable to see. That means the child was becoming blind. Hence, she took the child to another hospital. Ophthalmological checkup was done, and it was done in a Sharaf Charity High Hospital. And there they diagnosed ROP, and they said it is stage 5. That means total retinal detachment. The Rishabh Sharma had lost complete vision. Hence, on November 2007, Mrs. Sharma filed a consumer case against the Maharaja Agrasen Hospital, telling that they did not advise or do ophthalmic examination. or retinal examination. Hence, my child lost the eyesight. In this case, the court was very clear. Although the doctors were asked to pay compensation through the hospital, and the hospital was held responsible vicariously for their doctors who were not performed their act of doing ROP examination or else retinal examination. The apex court clearly established the hospital is vicariously liable for the act of negligence committed by the doctors engaged or empaneled to provide the medical care. It is common experience that when a patient goes to a hospital, the patient expects that the hospital provides a good care through the experts employed in that hospital. And they expect a reasonable degree of care. And if that does not occur, the hospital authority or the hospital will be held responsible for the negligence of their doctors. If the hospital fails to discharge their duties through their doctors being employed on a job basis or employed or on a contract basis, it is the hospital which has to justify the act of commission or omission by the doctors or the nurses or any other staff of the hospital. Hence, the Honorable Court clearly said to provide 76 lakhs as a compensation to the mother, my dear friends. That is vicarious liability. It is not only the doctor or the nurse for their negligence, the hospital will be held responsible for the negligence. Another important case which was decided in the Madras High Court, that is Aparna Dutta versus Apollo Hospital Enterprises. Here also, the High Court was very clear. The hospitals are vicariously liable of doctor's negligence. The patient wants due care and treatment and would not in any way know about the financial arrangements between the doctor and the hospital management. Here, the hospital may say, we have just provided the infrastructure. The doctor comes on case-by-case basis, or else he comes and sees the case and we will pay as per the cases. And he is not a regular employee. He is not even a contractual basis. He comes for his own cases. Those kinds of defense will not be agreed upon. It is both the doctor and the hospital will be held responsible. The hospital will be held responsible through vicarious liability. Let's understand what are the common defenses used by the hospitals or the corporate hospitals in medical negligence cases. It is a common defense used by the hospital by telling that they are not the regular employee. He is not on salary. He is on contractual basis. He comes per case and he takes his fees and he goes back. He is not a regular employee at all. We don't pay him. We provide infrastructure. We provide nurses. We provide beds. We provide equipments. And hence, the hospital is not responsible for the doctor negligence. Such kinds of defense has been used by many corporate hospitals when the doctor comes for per case pro rata basis, or else there is a possibility a doctor may hire the OT, that is operation theatre, of a hospital to conduct cases for his own patients. These are the defenses used by the hospital telling that we provide only the infrastructure or the staff. The doctor is completely independent. We do not control them. Hence, we should not be held responsible through vicarious liability. But however, it is not accepted at present. Even the National Consumer Court in 2003 has dealt this. They clearly said that a hospital cannot escape its liability by merely saying that it cannot suo motu perform any operation or amputation that is provided only the infrastructural support, nursing services, support, technician, equipment, medicine and place. The doctor is an autonomous entity and he is the master and the hospital does not hold responsible. If you want to pay any compensation, let the doctor pay. But the Consumer Court, the Supreme Court of India was very categorical. They clearly said the hospital will be held responsible through vicarious liability. Whoever is the doctor, whoever is the anesthetist, whoever is the staff may be even the D group worker or the attendant or maybe a contract employee, then the hospital will be held responsible through vicarious liability is the Consumer Forum's decision and also the Supreme Court decision. That means we need to differentiate between contract of services versus contract for services. What is this contract of service? The contract of service is the relationship between master and servant relationship. That is, a contract of service is an agreement binding on parties who are commonly referred as an employer and an employee. Here, the employee is completely under the control of the employer. That means the servant is under the control of the master. And the master is going to dictate terms and also how the job has to be done. He is going to employ him and also fire him if he doesn't do the work. Here the process of engagement is very clear. The control is very clear. The rules of engagement is very clear. The salary, the remunerations are very clear. That is contract of services. Now let's understand contract for service. What is this for service? Here it is contract for per services. That means a relationship akin to an agency. Generally, a person engaged via contract for services is not an employee. For example, a real estate agent or a broker who helps you to buy a house, hire a house, or maybe even a third-party software application. That means they are the brokers. They are the real estate agents. These agents will work for that particular contract period. And they are not directly under the control. You will be providing remuneration for the services. That means control is very minimal. Engagement is time limited, specific to the work. And after the work, the master do not have any control. That is the difference between contract for services versus contract of services. Contract of services means master servant, employer employee. Contract for services means you are providing a contract for providing a services. It is a broker, a real estate agent, or maybe you are subletting the work to somebody else. So that is contract for services. How to delineate? The hospital may say we have given the contract to third party. The doctor, he comes for per operation and goes off. That means he is not under our salary. Here the court clearly has delineated. They said patient approaches the hospital for the services the hospital has given. It may approach the doctor also. The patient holistically takes the hospital services and the doctor services. Although the doctor may be hired by the patient himself, or else the hospital would have given just the infrastructure's facility. Is the doctor free from the hospital control, direction, the infrastructure provided, the equipments provided? That means what is the relationship between the doctor and the hospital needs to be taken into consideration, and how long the doctor was working for them. Is it on daily basis, or else monthly basis, or weekly basis, or else per case basis? So these kinds of complex issue may arise many a time. Now the question is, what is the extent of relationship between the hospital and the doctor plays a very important case. In negligence, what was the role of the doctor? What was the role of the nurse, the patient, and other agencies? What was the medicine given? Who gave the medicine? Is it the hospital? How much the hospital is charging? That means the patient is not only paying for the doctor but also for the hospital. That means if the case goes well, both the doctor and the hospital are the beneficiary. Though the control by the hospital may be limited, but the hospital has the control over many other things, from providing infrastructure, admission, keeping cleanliness, keeping aseptic precautions, training the nurses, training the D group and other people within the hospital premises, and also keeping the equipments up to date. To conclude, my dear friends, vicarious liability is a situation in which one party is held responsible for the unlawful act of the third party. As per the legal maxima and rule, vicarious liability, an employer is liable for the negligence of his employee. A hospital is vicariously liable for the act of negligence committed by the doctors or nurses or any other person employed by the hospital and which occurs during the employment course, my dear friend. That is vicarious liability, my dear friends, and it is applicable in India, and both National Consumer Forum and also the Supreme Court has upheld vicarious liability, and the hospital has been held responsible along with the doctors for providing services, and during the medical negligence both are held responsible. Not only that, even the government who is employing the government doctors, if they do any medical negligence is there, both the doctors and the state governments have been also made paid to fine or compensation to the patient during the employment and the negligence which has occurred. That is what is vicarious liability, my dear friends. A doctor who has been negligent may not be the only defendant in medical malpractice. The defendant can be the nurse and also to the hospital. The hospital that employed the doctor can be held vicariously liable for the doctor negligence under the theory of Respondeat Superior. That is where both the hospital, maybe the state government, the central government who employ these doctors, when they hire, they also can be held responsible, my dear friends. That is vicarious liability, ladies and gentlemen. Thank you very much for your valuable time. Stay safe.